All right. Welcome back, everybody, to House Energy and Digital Infrastructure. We are shifting gears. We are working on H527, which is an act relating to extending the sunset of 30 VSA 248A. And so, as we like to do, we have Legislative Council here to walk through 30 VSA 248, whatever, 30 VSA, yes, 248A. So we understand what statute we're being asked to extend. So I'm Representative Kathleen James from Manchester.
Scott Campbell from St. Johnsbury.
Richard Bailey, Lamoille 2.
Chris Morrow, Wyndham, Windsor, Bennington.
Michael Southworth, Caledonia 2.
Christopher Howland, Rutland 4.
Dara Torrey, Washington 2.
Graham Klebner, Chittenden 13, Burlington.
Laura Sibilia,
Great. And in the room.
I'm Isabel with the Vermont Chamber of Commerce.
Great.
Gatorade Perry, Nebraska Group.
Super.
Claire Buckley from Leonine Public Affairs for CTIA.
Great.
And then Allison Despathy, Vermonters for a Clean Environment.
Super. All right. Big everybody. All right. For the record.
Ellen Cassidy, Office of Legislative Counsel. So I'm here on H527, which is a very short thing. What it does is extend by 3 years the sunset on 30 VSA Section 248A. Currently, that statute has a sunset in it that as of July 1, 2026, no new applications may be filed under it. And so this would extend it to 2029. And so the question is, what is it? Section 248A. So Section 248A is an option for siting permitting for telecommunications facilities. It was created in 2007. At the time, and still, telecommunications facilities went through the concurrent jurisdiction of Act 250 for a permit and municipal zoning for a permit. Initially in 2007, 248 was created for telecommunications facilities that were putting in multiple towers at once or over a period of 3 years. And then in 2009, it was amended to just be for any telecommunications siting project. They have the option of this siting process to go through instead of Act 250 and municipal zoning. So technically still within the statute, someone looking to construct and operate a telecommunications facility has the option to choose either Act 250 and municipal zoning or Section 248A, which is a process that is a permitting by the Public Utility Commission.
So if I understand, if you choose 248A, you can ignore municipal zoning.
Yes, they are facilities that get a 248A are exempt from municipal regulation.
And do you know, does the PUC take into consideration municipal zoning when they are considering 248A applications?
The municipalities are, yes. So one of the criteria that, I'm going to get to that, but the orderly development of the region, which relates to regional and municipal planning, is part of the criteria under 248A.
Thank you.
So you do have the Public Utility Commission coming tomorrow.
Right.
And so they will be able to answer things more specifically than I can, but I am going to walk you through the statute and what it entails, because I think, well, I'm not the regulator, so there will be some questions, because I have all the documents printed out here, but I have never been through a 248 case myself. The statute itself is 10 pages long, and then there are procedural documents that go with it. So like other permitting processes, these are things that require some level of expertise.
Yeah. And that's actually a great reminder, because I think this is the first time this session that we've had Ledge Council, well, besides Rick earlier, had Ledge Council in to walk us through the statute as sort of background. So it's a good reminder to me that you're here to walk us through the law as it's written and explain the law as it's written. And there's probably a lot of questions that we will all have on the bill as we move forward with the bill that are better suited for the PUC or for other experts in the field. So it's a good reminder to me, we got to stay focused on
And I'll
the
try.
walkthrough.
I'll
Yeah.
try, but I'm not. I'm a little rusty on this because it only comes up every 3 years.
Yeah.
And the statute. So as I started to mention, in 2009, when this process was created, and then since then, I think almost every time it has been renewed for 3-year increments. And the legislature has done that, I think, largely to check in to see if this is a process that is still working for all the parties involved. So it's a little unusual that it does come up every 3 years or so for review by the legislature. So the statute is 10 pages. Did you want me to walk through the statute?
Yeah.
Oh, okay. So
I think it'd be, do you guys agree? I think it'd be helpful. I'd like to walk through the statute, see what's in it.
okay. So 30 VSA 248A, Certificate of Public Good for Communication Facility.
Can we get it on the screen?
I don't have my laptop.
Okay. I don't think Alex can do that. Why don't we all take a minute?
Oh, sorry.
No, I'm gonna pull it up. Give me 1 sec. I can't share it on the screen, but I'm just give me 1 sec to get it up. All right, so we are in Title 30, Public Service. And Section 248A, so that's under Chapter 5, right?
Yep.
Okay.
And Chapter 5 is the chapter where most of the PUC's permitting authority is. And so you will recall that PUC issues permits for other things, including electric generation facilities, and we call those certificates of public good. So this is or CPG. So this is a CPG statute. It is in a lot of ways very similar to the 248 procedure, which is for electric generation facilities and energy storage and transmission. And so it's very similar to that process, but it is specific for communications facilities.
Okay.
So subsection A, notwithstanding any provision of law, if the applicant seeks approval for the construction or installation of telecommunications facilities that are to be interconnected with other telecommunications facilities proposed or already in existence, the applicant may obtain a certificate of public good issued by the Public Utility Commission under this section, which the commission may grant if it finds that the facilities will promote the general good of the state. So that's always the guiding principle. Certificate of public good, is it in the good of the state? Consistent with 202CB of this title, which is the statute that lays out the state energy policy. A single application may seek approval of one or more telecommunication facilities. An application under this section shall include a copy of each other state and local permit, certificate, or approval that has been issued for a facility under a statute, ordinance, or bylaw pertaining to the environment or land use. And so I'll also give another piece of information for context. So at the federal level, the Telecommunications Act of 1996 governs telecommunications facilities, and that piece of federal legislation largely preempts most of the regulation of telecommunications facilities, with a big exception, which is for land use. And so what has been left to the states is land use permitting. So it leaves up to it leaves up to the states whether or not that will be a local decision, i.e. at the municipality level, or a state level decision. And so a lot of states have it structured so that the municipality is the one who issue land use permits. And in Vermont, we still have that option if a telecommunications facility wants to go through the municipal permitting process, they can, or they can go through the state level process. So there may be things, as you hear the list of things that are part of this permitting process, you may think, shouldn't they look at blank? And the answer is potentially no, that's already been preempted by the federal regulation because the feds have a lot of say over telecommunications generally.
So what we're left with is largely where it can go.
Yes.
Okay.
And the environmental impacts under that and related to that. So then there's a number of definitions. Do you want me to read through all of them?
No,
Yeah.
maybe any that you find to be super important or relevant, or any that we need to really understand.
So there's a definition of ancillary improvements, and then de minimis modification. So these are sort of the smaller other associated parts of the telecommunications facility that are part of the analysis. Broadly, as I read through the statute, you will see there are sort of three different types of processes under 248A. There is a full 248A process, which is very similar to a CPG process. Then there are projects of limited size and scope. I'll read you that definition in a minute. And then there are de minimis processes. And so the definition for de minimis is an addition, modification, or replacement of telecommunications equipment, antenna, or ancillary improvements on a telecommunications facility or existing support structure, whether or not the structure was constructed as a telecommunications facility or the reconstruction of such facility or support structure. Provided that the height and width of the facility or support structure, excluding equipment, antennas, or ancillary improvements, are not increased, the total amount of impervious surface, including access roads around the facility or support structure, is not increased by more than 300 square feet. The addition, modification, or replacement of an antenna or other equipment on a facility or support structure does not extend vertically more than 10 feet above the facility or support structure and does not extend horizontally more than 10 feet. And additional equipment, antennas, or ancillary improvements on the support structure, excluding cables, does not increase the aggregate surface area of the faces of the equipment, antenna, or ancillary improvements on the support structure by more than 75 square feet. So the process for de minimis 248A is the most limited, and it is a very quick process. I think it's in here, I'll read through, but basically, if you're doing such small modifications to this facility that it's less than 300 square feet of impervious surface, less than 10 feet, either vertically or horizontally, less than 75 square feet is being added. It's a de minimis modification. And so we'll go through the fastest process.
From Siberia?
And if I recall, this is like fixed wireless antennas and or like battery or cabinets for cell towers. So it's not just the towers themselves.
Yes.
Okay.
The next definition in the statute is for good cause. And so good cause is used in a definition with substantial deference. So is there good cause to ignore the municipal input, which normally would get substantial deference? So it's a showing of evidence that the substantial deference required would create a substantial shortcoming detrimental to the public good or the state's interest. And then substantial deference is the plans and recommendations under C2, which is one of the notice provisions, are presumed correct, valid, and reasonable, unless there's good cause that they aren't. And so these definitions are going to be used further out, further on in the statute. Yeah.
Okay. So the PUC, in considering one of these projects, is required to show substantial deference to the local whatever, unless there's a reason to not.
Yes.
Okay.
Yep. So then definition number 4 is limited size and scope. And so this is the next sort of classification of 248A permit. So it's a new telecommunications facility, including the ancillary improvements, that does not exceed 140 feet in height, or in addition, modification, replacement, or removal of telecommunications equipment at a lawfully constructed facility or at an existing support structure and ancillary improvements that would result in a facility of a total height of less than 200 feet and does not increase the width of an existing support structure by more than 20 feet. So De minimis are the very small ones. This is then the next size, which is does not exceed 140 feet or add more than 20 feet of width. And then, additionally, part of that, it shall not disturb more than 10,000 square feet of earth. And disturbed does not means the exposure of soil to the erosion effects of wind, rain, or runoff. If earth is just moved temporarily, that is not considered disturbed under later part of the statute. And then there's a definition of telecommunications facility. Do you want to hear that definition, or do we think we all know what telecommunications facility refers to?
Okay, so folks, okay? Yep, move on.
And then there's also a definition of wireless service. So then subsection C of 248A is the findings. So before the PUC shall issue a certificate of public good, it shall find that. These are the criteria that they will look at as part of the review process. So these criteria are not applicable to the de minimis projects. So the proposed facility will not have an undue adverse effect on aesthetics, historic sites, air or water purity, the natural environment, and the public health and safety, and the public's use and enjoyment of the I-89 and I-91 scenic corridors, or any highway that has been designated as a scenic road under 19 VSA 2501, or a scenic byway under the federal statute. With due consideration having been given to the relevant criteria in 10 VSA 1424AD, and is that wetlands? And then also Act 250 criteria 1 through 8 and 9K. So this is very similar to the criteria that are used in 248 for electric facilities, but it's incorporating by reference the Act 250 criteria as well.
I wondered about that. So we can't have an undue adverse effect on aesthetics, historic sites. There's the list. And interestingly, that's interesting that it specifically then calls out the I-89 and I-91 scenic corridors. I just had a question about that this morning. It's so funny. And I was like, oh, really? And then can you explain to me then when you get to respect to telecom facilities of limited size and scope, what happens there? Later in that?
We didn't get there yet.
Oh, okay. We didn't even get there yet. Okay,
Yeah.
sorry.
No, because yes, I didn't get there yet.
Okay. Sorry.
So with respect to limited size and scope, the commission shall waive the criteria other than the Act 250 1D, which is floodways, and then Act 250 criterion 8, which is aesthetics, scenic beauty, historic sites, rare and irreplaceable natural areas, endangered species, and wildlife habitat. So the statute almost sort of reads in reverse of how I would have presented it, but you have these 3 size classifications for projects. I'm going to read you some more criteria, and the full list of criteria apply to the full size projects. But for limited size and scope projects, which are the medium size, they have a much smaller list of criteria that apply to them during the review. And that includes floodways and aesthetics. And for de minimis, it's an even shorter list of things that they're under review for. But such a waiver of the criteria for size and scope shall be on the condition that the commission may determine, pursuant to its procedures, that a petition raises significant issue with respect to any criteria of this subdivision, and a telecommunications facility of limited size and scope shall comply at a minimum with the requirements of the low risk site handbook for erosion prevention and sediment control issued by the Department of Environmental Conservation. So there is a comment period for limited size and scope facilities, and during that comment period, anyone can weigh in and raise that while the criteria aren't necessarily always applied to limited size and scope, that this particular project does raise a concern under the other criteria and that it should be brought into the for review for that project. So still under findings, number 2, unless there is good cause to find otherwise, substantial deference has been given to the plans of the affected municipalities. So the PUC is going to look at, did the municipality have planning around the location of telecommunication facilities? And they get substantial deference if so, but is there good cause to find otherwise? So it's to the recommendations of the municipal legislative bodies and the municipal planning commissions regarding the municipal plans and the recommendations of the regional planning commission concerning the regional plan. Nothing in this section shall prevent a municipal body from basing its recommendations to which substantial deference is required on an ordinance adopted under their ordinance authority or a bylaw adopted under their municipal bylaw authority. A rebuttal presumption respecting compliance with the applicable plan shall be created by a letter from the affected municipal legislative body or planning commission concerning compliance with the municipal plan, or a letter from the regional planning commission concerning compliance with the regional plan. Number 3, if the proposed facility relates to the provision of wireless service, the proposed facility reasonably cannot be co-located on or at an existing telecommunications facility, or such co-location was cause an undue adverse effect on aesthetics. So for wireless facilities, they look at whether or not the applicant explored co-location as a possibility.
Favorable.
Yeah.
It sounds to me like I might be reading this wrong. Sounds to me like they're discouraging co-location. No, encouraging.
Yes.
But in other words, another antenna on an existing tower.
Okay,
Is that correct?
okay, thanks.
Oh, excuse me, in addition.
Okay.
But without the same caveats of the square footage and 10 feet and all these other things that were in a previous paragraph. De minimis, it was under the de minimis of the.
So it could fall under de minimis, but there is additional language under this section too.
There's some square footage, but that was de minimis, so that they could be greater than the size that was in the de minimis in this area.
They could be, yes.
Okay.
Yeah. And so if a proposed new support structure for a new telecommunications facility that provides wireless service will exceed 50 feet in height in a cleared area, or will exceed 20 feet in height above the average tree line measured within a 100-foot radius of the structure in a wooded area, the application shall identify all existing telecommunication facilities within the area to be served by the proposed structure, and for such existing facility shall include a projection of the coverage and an estimate of additional capacity that would be provided if the applicant's proposed telecommunication facility were located on or at the existing facility. They shall compare such projection and estimation to the coverage and capacity that would be provided at the site of the proposed structure. So this fleshes it out even a little bit more. If they're trying to propose a new structure that's near an existing structure, do they have a proposal that is actually that this new structure would provide additional coverage and wireless service than adding it to an existing structure would have? They need to make that demonstration.
Mm-hmm.
Otherwise, the PUC does not encourage new structures over co-locating.
Okay.
To obtain a finding that the proposed facility cannot reasonably be co-located on or at an existing facility, they must demonstrate that co-locating will result in sufficient reduction of the area being served or the capacity provided would impede coverage or capacity objectives for the proposed facility. Proposed antennas or equipment will exceed the structural or spatial capacity of the existing or approved tower. And the existing tower cannot be reinforced, modified, or replaced to accommodate planned or equipment at a reasonable cost. The owner of the existing facility will not provide space for the applicant's proposed equipment or on a commercial, or won't at a commercially reasonable terms. So the existing owner is not gonna let them in or gonna charge them a lot of money. Or the proposed antenna or equipment will cause radio frequency interference that will materially impact the usefulness of other existing or permitted equipment at the existing tower, such that it can't be mitigated at a reasonable cost. So again, these are the factors they look at whether or not something can be reasonably co-located. Existing permits. When issuing a certificate of public good under this section, the commission shall give due consideration to all conditions in an existing state or local permit, and shall harmonize the conditions in the certificate of public good to the extent feasible. Subsection E is notice. So this is not going to apply to the de minimis process, but one aspect of section 248 that is interesting is that there is a pre-application notice. So no less than 60 days prior to filing the application for CPG, the applicant shall serve written notice with the commission to the legislative bodies of the municipal and regional planning commission in the community in which the application is proposing to install the facility, to the Secretary of Natural Resources, the Secretary of Transportation, the Division of Historic Preservation, the Commissioner of Public Service, and its Director of Public Advocacy, the Land Use Review Board, if it concerns, if it's a facility that previously had an Act 250 permit, and the landowners of record of the property adjoining the project site. At least one copy shall be filed with each of the municipal and regional planning commissions. Notice to the legislative body and planning commission shall attach a statement that itemizes the rights and opportunities available to those bodies that get notice, including subsections M, N, and O of this section, and informs them of the guide published under section P and how to obtain a copy of this guide. So there's a guide required by the statute on how all of this works, and is available to the public on how to participate in this. So this 60-day pre-application notice is provided to the state agencies and the adjoining landowners to give them an opportunity to weigh in on the application and sort out any problems before it's actually applied for at the PUC, and before the review process actually starts. And so this is not for the de minimis projects, it's for the larger projects. If upon motion, the PUC shall direct further personal or public notice to be provided if they find that further public notice will not unduly delay consideration of the merits and is necessary for fair consideration of the application. On request of the municipal legislative body or planning commission, the applicant shall attend a public meeting with the legislative body or planning commission or both within the 60-day notice period. The Department of Public Service shall attend the public meeting at the request of the municipality. The department shall consider comments made and information obtained at the meeting and making recommendations to the commission on the application and determining whether to retain additional personnel. So the Public Utility Commission, through the Director of Public Advocacy, acts as the public advocate or an advocate for the public at these 248A hearings. And so DPS attends the public hearings to hear what the comments and complaints are so that they can represent those positions before the PUC. With notice required, the applicant shall include a written assessment of the co-location requirements that I read to you before that pertain to the proposed facility. On request of the municipality, the Department of Public Service shall retain an expert to review the applicant's co-location assessment and conduct further analysis if necessary. Within 45 days following receipt of the applicant's notice and co-location assessment, the department shall report its own preliminary findings and recommendations regarding co-location to the applicant and to all persons required to receive notice. So DPS can do independent review or hire an expert to do independent review of the co-location to test if they met the requirement about coverage and if a new facility is necessary over co-locating. Subsection F, review period. If the PUC determines that an application does not raise a significant issue, they shall have to issue a final determination on the application within 60 days following its filing. Or if the original filing did not substantially comply with their rules within 60 days following the date on which the clerk notifies the applicant that the filing is complete. So if the application is submitted and there's no significant issues raised, the PUC has to issue their decision within 60 days. If there is a significant issue raised, it shall issue a final determined application within 180 days following the filing. Or again, if they did not substantially comply with the requirements within 180 days following the day at which the clerk determines the application is complete.
Sorry. So, if the significant issue is not raised, then the PUC has to issue its determination within 60 days. And what's the 180?
If there is a significant issue.
Okay.
And the reason that is because there will be at least one hearing if a significant issue is raised. And I think I'm probably going to get to that.
Okay.
But I know I feel like the statute is kind of written in reverse of how the process plays out. But,
Yeah.
Subsection G, letter of intent. Nothing in this section shall be construed to prohibit an applicant from executing a letter of intent or entering into a contract before the issuance of a certificate of public good, provided that the obligations under the letter of intent or contract are made subject to compliance with the requirement of this section. Subsection H, exemptions from other law. An applicant using the procedures in this section shall not be required to obtain a permit or permit amendment from an municipal zoning permit or an Act 250 permit that they may have already received. This exemption from obtaining a permit shall not affect the substantial deference given to the plan or recommendation by the municipality. An applicant using this procedure shall not be required to obtain approval from the municipality under any ordinance that they may have adopted or a charter that would have otherwise applied. Disputes over jurisdiction under this section shall be resolved by the Public Utility Commission, subject to appeal as provided in section 12 of this title, which allows appeals from PUC decisions to go up to the Supreme Court. An applicant that has obtained or been denied a permit or permit amendment under municipal zoning permit or Act 250 may not apply for approval from the commission for the same or substantially the same facility. So if someone has already attempted to go through the Act 250 / municipal process and then been denied, they can't then apply to the PUC. Subsection I is the sunset. And so this is the subject of H527, effective on July 1, 2026, no new applications for a certificate of public good may be considered. And so that date has been being re-upped since the statute was created in 2007. Subsection J lays out the procedure for projects of limited size and scope. So the commission may, subject to such conditions as it may otherwise lawfully impose, issue a certificate of public good in accordance with the provisions of this subsection and without the notice and hearing requirements by any provision other than subdivision 2 of this subsection, if it finds that the facilities will be of limited size and scope, and the application does not raise significant issue with respect to the substantive criteria of this section. The commission may make findings based on the application and supporting evidence submitted by the applicant. If the applicant requests approval of multiple telecommunications facility and a single application, the commission may issue a certificate of public good in accordance with the provisions of this subsection for all or some of the telecommunications facilities. Any person seeking to proceed under the limited size and scope shall file a proposed certificate of public good and proposed findings of fact with its application within 2 business days following the notice from the PUC that the filing is complete. The applicant shall serve notice and a copy of the application, proposed certificate of public good, and proposed findings on the Commissioner of Public Service and Director of Public Advocacy Secretary of Natural Resources, Division of Historic Preservation, and Land Use Review Board, if there is a permit, a previous Act 250 permit, and the legislative bodies of the municipality and the Regional Planning Commission, where the project is located. Within 2 business days, the commission, following notice that the filing is complete, the applicant shall also serve notice on the landowner of record of the properties adjoining the project site or site, unless the commission has previously determined that good cause exists to waive or modify the notice requirement to the landowners. Such notice shall request comment to the commission within 30 days following the date of service on the question of whether the application raises a significant issue with respect to the substantive criteria. If the PUC finds that the application raises a significant issue, the commission shall hear evidence on such issue.
So the adjoining owners are directly notified 60 days before the application is filed and then after it's been approved.
No.
Here, it appears to be some exception that some finding the adjacent landowners don't have to be notified.
Yes, I'll get to your question next. So let's see. Oh, yes, no. So for limited size and scope, there is a 60-day advance notification, and then there is notice that the application has been filed and provides them the opportunity to provide comments within the 30-day comment period.
Okay.
And then the PUC determines at that point if a hearing is needed,
Okay.
because a hearing is not automatic for limited size and scope.
So we're going to file, we have filed.
Yeah.
Okay.
Yeah. So this is a provision that related to the PUC can decide if the adjacent property owners are sort of too voluminous, or if they're redundant. So this provision is in 248 and in the Act 250 statutes, because a lot of them require notification to the adjoining landowners. In some cases, it can be hundreds or dozens of adjoining landowners if it's a very large parcel and it's like a whole neighborhood. And so they may require just a general public notice in the area as opposed to individual notice to every single landowner. You may want to hear from the PUC when they use that provision in the past, but it is, yeah, it's usually because they may have a different way of communicating with those people as opposed to individual mailers to all of them.
We haven't seen anything about elevation of the land that this is being cited on. The voluminous, too many landowners, I look at, you can't build a home above 2,000 feet, so you've got, somebody owns the mountain, what's left of the mountain, and all the land that's down below that's got road torn everywhere and subdivision lots. But that's my perception.
Yeah, maybe there isn't anything specific in here about elevation. But that is a slightly unusual provision about modifying the notice. You may want to ask them about examples they've had before. So the next subdivision under this actually is about the notice to adjoining landowners. An applicant seeking a waiver or modification of the notice requirements shall file a request for such waiver or modification with the PUC not less than 30 days prior to serving written notice on those people, together with the description of the project, its location, and the reasons for seeking a modification, and the applicant's demonstration that the standard for granting the waiver or modification is met. Any granting of such a waiver shall be based on a determination that the landowner subject to the waiver could not reasonably be affected by one or more of the proposed facilities, and that notice would constitute a significant administrative burden without corresponding public benefit. And the PUC shall rule on this request within 21 days following. So that's one of the considerations there. If the PUC accepts a request to consider an application under limited size and scope, Then unless the PUC subsequently determines that the application raises significant issue, the PUC shall issue a final determination on the application within 60 days. And if they rule that there is a significant issue, they shall issue the determination within 90 days of the filing of the application. I have a cheat sheet that I assume the PUC is going to bring in, but they have this procedure with like flow charts in it on their website. They also have a written handout that describes more of the procedures. I didn't think I should bring them because it is their documents that they created, but they do have helpful notes for the public, and that is required in the statute, as I already sort of alluded to.
Okay.
Subsection K is the de minimis process. I've already mentioned it a couple of times. So an applicant intending to make a de minimis modification to a facility shall provide written notice of its intent, including a description of the modification, its plans for the modification, and its certification that the project constitutes a de minimis modification. This notice shall be to the following: the landowner of the property, the legislative body of the municipality, the Commissioner of Public Service, Director of Public Advocacy. Unless an objection to the classification of the proposed project as de minimis is filed within 30 days following this notice, a CPG shall be issued. Objections may be filed only by persons entitled to notice of this project. If an objection of the classification of the proposed project is timely, the commission may determine whether the project meets the definition of de minimis under the statute. So for de minimis, there is just this notification requirement, and then there's a 21-day comment period open. If there is no substantial or a significant issue raised with the definition, or if they meet the criteria, the basic criteria, then the PUC has to issue the determination right after the close, the 21-day comment period. So it's a significantly shorter time frame than the others. Subsection L is the rules provision. So the PUC may issue rules and orders implementing 248A. They shall seek to simplify the application process as appropriate for the categories. They may, by rule or order, waive the requirements of this section if they determine they're not applicable to the facilities that are of limited size and scope. Subsection M is municipal participation. The legislative body and the planning commission, where the proposed facility is located, have the right to appear and participate in any application under 248A. And then subsection N is their recommendations. So the PUC shall consider the comments and recommendations submitted by the municipal legislative body and planning commission. The PUC's decision to issue or deny a CPG shall include a detailed written response to each of the recommendations of the municipal legislative body or planning commission. Retention of experts is subsection O. The Department of Public Service may retain experts and other personnel identified in subsection 30 VSA section 20, which is their ability to hire independent experts to provide information essential to a full consideration of the application. The department may allocate expenses incurred in retaining these personnel. It's what we call billback authority. So if they need to hire an expert to review the application, they can potentially bill back the applicant for those costs. The department may commence retention of personnel once the application has filed the 60-day notice period. The municipal body or planning commission may request the department retain these personnel. Granting such a request shall not oblige the department or personnel it retains to agree with the position of the municipality. Subsection P is the review process guide. DPS, in consultation with the commission, shall create, maintain, and make available to the public a guide to the process of reviewing telecommunications facilities under this section for use by local governments and regional planning commissions and members of the public who seek to participate in this process. So on or before September 1, 2014, the department shall create this guide and make it publicly available. So I'm pretty sure that's what this is.
I was gonna ask, okay,
I think that's what this is. There's also on the PUC's website a longer, more written narrative that they have available. That's what it's only 6 pages instead of 10 pages. But it does have like a flow chart in it showing the steps, so it's useful.
okay.
Subsection Q, and I am almost done. Subsection Q is the emergency waiver. So when the governor has declared a state of emergency, and for 180 days after the declared state of emergency, the PUC may waive for a specified and limited time the prohibitions on site preparation or construction for temporary telecommunications facilities for maintaining or improving access to telecommunication services. Waivers issued under this subsection shall be valid for a period not to exceed the duration of the declared emergency plus 180 days. So, during a time of emergency, telecommunications facilities can go up quickly without going through the CPG process. After the declared emergency ends, they then have to apply for their CPG.
Has that happened?
Yeah. So we worked on this during COVID.
Cows. Right?
Cows? I don't know. Didn't we work on this during COVID at one point?
God,
Yeah,
don't make me go back.
I know. So I think it has been used,
Mhm.
but you could ask the PUC that.
Yeah, I was just curious. Seems COVID-y.
So they have to file a petition with the PUC and provide copies to DPS and Agency of Natural Resources that they're doing this. And the PUC shall conduct an expedited preliminary hearing. An order granting a waiver will include the terms, conditions, and safeguards to mitigate significant adverse impacts, including posting a bond or other security based on the scope and duration of the request. A waiver shall be granted only when the commission finds that good cause exists due to emergency situation. The waiver is necessary to maintain or provide access to wireless telecommunication services. Procedures will be followed to minimize significant adverse impacts under criteria and taking into account any terms, conditions, or safeguards they may require that this will promote the general good of the state.
That's all for temporary.
Yep.
So,
Yeah, and upon expiration, if the certificate of public good has not been issued, the PUC shall require the removal, relocation, or alteration of the facilities. So, yes, so they're supposed to give notice to the PUC and DPS and ANR that they're going to construct these facilities quickly, and then they have to actually apply for and receive a CPG hopefully before the emergency has ended, but before the expiration of the 180 days. Yeah, I'm not sure. I think, it's come up a couple of times since I've been here, but I don't know if anyone has actually used this procedure. So that's the whole statute. There are documents that the PUC has issued that put this in in an easier to read way.
okay. And we're hearing from them tomorrow morning. So, yeah, Rep. Sedelia.
And so to be clear, if we take no action this year, this section of law is repealed.
No, it prohibits further people from applying. So it's not an automatic repeal, it just is a sunset on people being able to apply and use this process. It then would force people to use the Act 250/municipal permit process if they were seeking to construct telecommunications facilities.
Don't apply.
Yeah. And so this section doesn't really give you what happens at a hearing. So, and you can talk to the PUC about this tomorrow if you'd like, but for full projects, not limited size and scope or de minimis necessarily, but there is usually an evidentiary hearing going over the criteria. People can apply, all those people who got notice may or may not be statutory parties. The municipality is a party, DPS is a party, but other people can apply to intervene and become a party in the case, there is a separate PUC rule laying out what the standard is for intervening as a party to join a case. And then a hearing is held. It is a bit of a formal process at the PUC. It's not exactly court, but it's very similar to court. So yeah, the statute doesn't really detail how that process works, so you may want to hear from them about that.
Okay.
I'll also add one tidbit. Well, I don't want to open a can of worms, but Representative Sibilia may remember that further under the federal law, there's something called the shot clock.
Shot clock?
Shot.
Oh,
Like in basketball.
the shot clock.
The shot
Okay.
clock. So in addition to having largely preempted the field on regulating telecommunications, one of the things that the Telecommunications Act requires is that if states or municipalities are going to be doing this permitting, they have to do it within a reasonable time. So there's a shot clock. And I don't have the dates in front of me, but it's either 90 days or 150 days, depending on the complexity of the project. And so in the past, I had looked at whether or not our statutes comply. The PUC is aware of the federal requirements, and so they aim to comply with those federal requirements. And I think they get them under the clock requirement generally.
Okay.
So just something to be aware of, and that is why there are times in this statute that they have to comply with.
Does
Okay.
the federal requirement preempt the state?
It does.
Okay.
Yes.
Okay. Ellen, thank you so much. Yeah, really appreciate it. We had a little agenda change. It's been posted on the website, but Rep McCoy was able to come in earlier, which I appreciate. So I scrapped my bill intro. We can do that some other time. I just wanted to make sure that we had time for Rep Southworth and McCoy. We do need to adjourn by 4:20 at the latest. So keeping in tradition with, every bill gets 15 minutes. Just as a quick intro, almost like a pitch from the sponsors, that's what we're doing now. So we can get to my bill down the road, and we'll just take a quick break.